The House State Civic, Military and Veterans Affairs Committee will come to order. Ms. Jackson, please call the roll.
Representatives Bottoms.
Here.
Bradley.
Here.
Carter.
Present.
Espinosa.
Excused.
Foray.
Here.
Froelich. Here. Luck.
Here.
Mabry.
Excused.
Ricks.
Present.
Clifford. Here. Madam Chair.
Here. All right, we have two bills on the calendar today, and we will start with House Bill 1225. Welcome, Representative Woodrow. And I believe Representative Velasco. Have you been approved? Yes. Okay, perfect. Please introduce your bill.
Good afternoon, committee. It is so nice to be back. 5 straight sessions on state affairs. It is so nice to see you all here. Tremendous. Good afternoon. I want to thank all of you. I want to thank my co-sponsor, Representative Velasco, for her collaboration on this bill. In a time when voters express concern and confusion about our elections, how ballots are counted, voter fraud, we find our American democracy under unprecedented pressure. Unfortunately, there have been threats of political violence and intimidation targeted at voters, election officials, and election workers. There have been several incidents right here in Colorado in 2020. A mobile park homeowner was intimidating voters, and the Attorney General's office had to send a cease and desist letter. In 2022, poll watchers yelled at and recorded election workers inside the El Paso County Clerk's office. Since 2023, our Secretary of State has received over 1,000 threats of violence and death. I know that members in our own caucuses, in our own chamber, our own General Assembly, our colleagues have received threats of violence and death. And in 2024, a Cortez resident pleaded guilty to making multiple violent threats against Colorado election officials. Incidents like these have created, at times, a tense and hostile climate around elections. And Colorado has seen, unfortunately, 40% of local election officials leave their positions since 2020. House Bill 1225 adds additional protections to existing laws to protect workers and election officials. This bill does the following. If a voter or election worker has experienced intimidation in election activities, they can request a restraining order in state court. And an individual who threatens, coerces, or intimidates others can be found civilly liable for damages. And I want to emphasize this point that 1225 creates only a civil cause of action. There are no criminal penalties. Money damages can be a powerful deterrent from people who would otherwise act unlawfully. 1225 also creates a presumption of intimidation if an individual is carrying a visible firearm at the time of the incident. A defendant can, of course, rebut that presumption. HB 1225 will protect Colorado civil servants who continue to show up and use their expertise to administer our elections safely and securely. They deserve to know that we have their backs and that we will do what's within our power to protect them. Other states have passed similar laws that allow for these types of civil protection for voters and election workers, and Coloradans deserve no less. I do want to note that we will have 2 amendments that'll be passing out. L001 clarifies that the visible firearm presumption does not apply to law enforcement or security hired to work at polling centers or buildings where polling locations are present when they're acting within the scope of their duties. And L002 clarifies that enforcement action taken against an election judge for a violation of state law or a rule promulgated under the Secretary of State or a judge's oath is not actionable under this act. And with that, I'll turn it over to my co-prime.
Representative Velasco, welcome.
Thank you so much, Madam Chair, and thank you to my co-prime, Representative Woodrow. So this bill strengthens our existing protections for election workers, election judges, and voters by giving legal recourse to victims of intimidation, where currently none exists. Currently, the state can bring criminal charges for election intimidation, but individuals have no civil recourse. So or House Bill 1225 will allow them to pursue money damages and restraining orders and allow past election workers officials to pursue civil remedies, as well as current election workers officials, even when they are not performing their official duties, provided that the threats of violence were made because of the victim's status as an election worker. There has been over 1,000 threats levied against election workers in the past 5 years alone. And during the 2024 election, at least one top election official had left in 25 over Colorado's 64 counties. So, and Representative Woodrow already shared this, but 40% of the officials in charge of the 2024 presidential election were new to the job. The state has seen a net loss of 126 years of election experience. And this bill will deter threats and support victims, making our elections safer and helping to retain our public servants working in this essential field. Colorado is a gold standard for election integrity in the nation, and we must continue to protect and uphold that integrity. So with that, I ask for a yes vote.
Thank you very much, sponsors. Members, what questions do you have? All right, Rep. Bradley, and then we'll move over to Rep. Luck.
Can I dialogue, Madam Chair?
Sure.
Thank you. So I have a ton of questions. I see my Second Amendment right as my constitutional right. I don't see it as viewed as intimidation. In fact, I think we should take social media away in people's mouths. The amount of times I've been called, what I've been called, and I think people on here would agree. For me to be able to carry to go vote makes me feel a lot more secure from the unhinged people that get on their keyboards and say the crazy things. So tell me why taking my son's cap gun is going to make people feel better about going to vote, and why that's going to make me feel better from the lunacy that I think has been spread. Why that's going to make people feel better.
Representative Woodrow.
Yes, thank you. And thank you, Representative Bradley. And I understand your passion on the Second Amendment and what it means to you. And I've listened intently, and I in no way, shape, or form want to call that, bring this bill forward in the spirit of taking that away in any way. This is about folks, not caring to protect themselves, but to intimidate others. And for a claim to be brought like this, I think there would need to be, some type of significantly clear violation. Otherwise, no one's going to waste their time breaking this. And certainly, folks who need protection and those with concealed carry are not impacted by this at all. This is only about folks who are noticeably, visibly brandishing a firearm by a polling location with the intent of intimidating others. And I think we would both agree that that's far from anything that you're talking about. And I don't see that as being actionable.
And I appreciate that, because I think that most people that I hang around don't do that, but there's presumptive intimidation. I mean, some of us wear MAGA hats, and we've been treated poorly by the people that say that kindness matters. And so I see it all over the news. We're the most, I just was in a meeting that says we are the most polarized state. Colorado is the most polarized state. We just had 2 Democrat senators just leave. We've had plenty of others leave. I wonder where this is coming from, because to me, it almost feels, with all due respect, another poll tax or literacy test, because the very people that you're going after in your ledge deck, praying people are intimidating. And you talk about 40% of local election officials in Colorado that have left their positions. We're polarized, right? We're the most polarized state. This isn't about gun intimidation. They've left because we're so polarized. Again, 2 Dems out of 35 have just left. So to come after Second Amendment carriers, I don't believe these are the people that are intimidating folks, because your ledge deck doesn't even prove that. So if you would elaborate on that, that would be great.
Go ahead, Representative Woodrow.
Thank you, Madam Chair, and thank you, Representative Bradley. we are a polarized state. I think we're a polarized country. I think one way that we bridge the gap is through leadership and leading by example. And I've certainly fallen short at various times of being conciliatory. But I also know, working with you, that we have often found common ground, whether it's on policy or Kevin Bacon or other, avenues of finding commonality. When we recognize the humanity in each other, I think that we take the temperature down an awful lot. Now, with respect to this bill, most of this is already the law. It's existing law. What this does is it says, if these violations of existing law occur, now you have this added remedy, which is the ability to go get yourself a TRO. In order to do that, you got to go in front of a judge. And I have some experience with this. It's not easy. Going in front of a judge and making your case and getting them to agree with you, even when the facts are clearly on your side. So I don't see this as something that's going to be opening the door or having a chilling effect. It's already existing law plus a new remedy. And so, again, not trying to bring it in, any spirit, targeting any folks. And I will note that there's too much vitriol. I don't think social media is great for us either. But that's a different conversation.
Thank you.
Representative Luck.
Thank you, Madam Chair. And may I also dialogue?
Sure.
Thank you, Madam Chair. Good afternoon, guys. So starting on page 3, Ledge Deck, I'm wondering, in these examples that you provide, there are 4 that you have laid out here. How many of them included the presence of a firearm?
Representative Woodrow.
We're dialoguing.
Yeah, I
I'm
know. I just want
sorry.
to make sure.
I'm
you knew.
sorry, Madam Chair. Thank you, Representative Luck. I'm not sure, and I can get you the answer to that. And we're also going to have a couple panels of witnesses, and you can ask them that as well. I would note that the Brennan Center for Justice is here, and they're probably going to be in a position to answer that question. Otherwise, we can have it looked up for you.
Thank you. My next question is as relates to that same page, section C, talking about the folks who have left office. Of those folks, do we have any indication how many left simply because they were termed out versus because they were being intimidated versus they just were tired of all of the drama that is currently elections? I mean, that there is a difference between having folks come into your office and being frustrated with the election system and being intimidated to the point of needing to leave versus being termed out or aged out. And there's a lot of things that factor in. Do we know the breakdown of that?
Yeah, thanks for the question. I'm not sure how granular the data get, but happy to look into that as well. And try to get you an answer, whether we have that specificity or not.
Okay, thank you. Looking at page 5, I do have some questions about page 4, but holding those for a minute. Page 5, section C, voting includes all actions necessary to make a vote, blah, 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 blah. In any primary, blah, 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 candidates for public or party office. My question is, do you mean to include party caucuses, party state assemblies, party reorganizational meetings, party blue book parties? So I don't know if you and your party do this, but we have blue book parties where we invite folks to come and we talk through things, election town halls that people might host. Are all of those contemplated here, or are we looking at just those things that interact with the county clerk's power and authority, like a particular ballot drop box or the county building?
Yeah, so I appreciate the question, and zeroing in on line 19, the definition of party office. I can get you more clarity there, but I would think that we wouldn't want intimidation, for any of those elections. I can't speak to the blue book elections that you're referring to. I don't believe that we have them. Maybe we call them something else. But I don't think that we would want intimidation during those elections either. And again, this isn't just about walking around carrying and talking to folks, et cetera, where you're allowed to do that. But like I said, we wouldn't want intimidation, whether it's, someone running for public office or, chair of the Republican, Party of Colorado. I wouldn't want to see it in that situation either.
Well, I guess where I get hung up is on page 6, starting in section 4. An individual who carries a visible firearm is presumed, in the absence of any affirmative showing to the contrary by a preponderance of the evidence, to have engaged in intimidation prohibited by this section. So in our party meetings, caucuses, what have you, especially in my district, you're going to see a lot of folks open carrying. And yet, the way that I'm reading this, there is a presumption that simply open carrying is intimidation. And a lot of people would not believe that that is intimidating. Now, there are some folks who are moving into my district who are very fearful of firearms, who don't share our culture and our history, such that if they see one, yes, they are intimidated by its very presence, but that doesn't mean that the intention of the person carrying it is to intimidate. And so I guess I'm trying to understand, are we suggesting that someone just open carrying is intimidating, or do they have to do something more than just having that pistol on their hip?
Yeah. Oh, if we're dialoguing. We can have, I would encourage this same question to be asked of a panel. My interpretation of this would be no, because, to the extent that there is, some sort of understanding that is customary, there would be some type of rebuttal to the presumption that the carrying is with the intent of intimidation. So I would encourage that to be asked of a panel member, but again, this isn't to upend currently existing law. It is to add a remedy on. And with respect to the brandishing provision specifically, I don't read it that way, but again, ask a panelist for clarification.
Okay. And so if I can just restate what I'm hearing, you don't think that anyone would be found responsible or liable for intimidation by a court, but you're not wholly convinced that they wouldn't be brought before the court and have to rebut that presumption.
They would need to be sued by someone who interpreted it as intimidation. And I hear what you're saying about people moving into your community who you feel don't, share necessarily your values or history there. But at the same time, if that is not actually intimidation, I think that you'd have a pretty strong case, and no one would actually bring that. Again, this is a remedy for when it's clear, and you can go to court and say that you need a TRO or a preliminary injunction, or potentially damages if worse. So these aren't sort of like the fly-by-night, hypersensitive observer situations.
Okay, thank you. On page 7, under relief, it says a court may grant relief in joining a defendant from the use, it's lines 19 through 24, from the use or carrying of firearms beyond the areas described in these 2 sections. What do you contemplate related to that, such that is this contemplated to mean that they could be banned from carrying firearms anywhere?
No, I would think that it's probably within a certain distance from the individual.
Okay, so traditional.
Who's bringing the action.
Okay. Then the last question, going back to page 4, we note, or on lines 20 and 21 that there is a fundamental right to vote. Do you also recognize there is a fundamental right to self-defense that could include the ownership and use and bearing of a firearm?
I recognize that there's an inherent right to self-defense and that we have a Second Amendment right that has been interpreted to include a right to firearms. And I don't believe I've brought any bill in my time here that has violated either the Second Amendment of the United States Constitution or our comparable provisions under the Colorado Constitution. I understand that folks have a right to keep and bear arms, and this bill does not infringe on that right.
Thank you.
Thank you very much. Representative Clifford.
I just looked this up, Rep. Woodrow. So 113.724, it's already illegal to open carry a firearm within 100 feet of a polling location. And I think you've explained it well, that what we're doing here is adding the civil penalty. What I don't understand in the process of the TRO is what it accomplishes. Can that be done quickly enough to stop that intimidation at the ballot box? Is this something that's happening ongoing over the day? Can you describe the issue a little?
Yeah, sure. Excellent question. So a temporary restraining order is immediate injunctive relief that you can get granted by a court. You have to make a showing of irreparable harm. You have to make a showing that it wasn't practical to give notice to the other side that you're coming before the court. TROs are granted in extreme situations, but they are granted. And you'll see TROs granted when executive orders are entered. You'll see TROs entered when people are causing threats to other people. And you'll see TROs when there's a condition, let's say that is inherently transitory. And so by the time you get to court 3 years later, everything's going to be different, right? And so you need to sort of freeze things in time and get relief early. All those powers a court has. And so, yes, it's something that can be granted on an emergency basis very quickly.
Permission to dialogue.
Sure. Vice Chair Clifford.
So I appreciate that this can be done very quickly. Is the issue that someone is coming to a ballot box and doing this over a period of days? Is it typically just a person that's come to the ballot box that has a firearm on? Like, what is the presumption here?
Sure. I would ask the witnesses this. You can imagine either scenario. I mean, sometimes it's one-off, but also sometimes it's menacing. And people come back repeated. You have a law enforcement background, so you probably understand this much better than I do. But I'm sure there's instances of both. And it's probably a rarer occasion where it's just one person making a one-off. So, we're talking about instances when someone would be compelled to actually seek relief from a court. That's when they would be of the belief that it would happen again.
But both compelled to seek relief, and the court would have to recognize that this is like someone that is showing up to intimidate. They wouldn't issue a temporary restraining order unless there was something happening there. So in reality, the only thing that this bill does then is gives a civil court the ability to say, you must leave.
That and damages. And so, but the initial relief is yes, a temporary restraining order. And that's just like its name suggests, temporary, right? Once you can have an opportunity for the defendant to be heard, okay, you then convert the TRO into something called a preliminary injunction. So, you initially get the relief, and then there's a period of time where it's on a truncated, collapsed schedule where you then have the defendant heard to see, is this something that, we should have a preliminary injunction entered for a period of time, or do we extend the TRO in essence while the case is pending?
Are we having an issue with law enforcement enforcing the existing law? Because I can see that now, if someone has open carry of a firearm outside a polling place or a ballot box and you contact law enforcement, that is a misdemeanor already, with jail time and $1,000 fine if they come and find you openly carrying at a ballot box. Currently, why the need for the additional civil action, I guess, would be more the question. Or also the first question, two questions in there. Is law enforcement not enforcing this?
Yeah. Can I take the second part first?
Okay.
You're asking a civil lawyer why a cause of action is necessary. Yeah, there's nothing more powerful than the threat of a civil suit. Law enforcement's bandwidth, as you know, is not infinite. And when the individual most impacted is empowered to go get relief themselves, that's even more impactful than what law enforcement could do. So, and with respect to the first thing, again, I would ask the panel, I could imagine situations where law enforcement would look at a situation like this and not necessarily want to get involved until it's unfortunately perhaps too late. And this is something that our civil courts and our civil justice system would be equipped to handle.
Thank you. No further.
Representative Espinosa.
Thank you, Madam Chair. Representative Woodrow, so to the point that you just described this as a civil action, I guess the issue that I've had with this legislation is why you're using what is normally more of a criminal strict liability standard as your intent in the civil action. And if you could just speak to that distinction for me, that would be great.
Representative Woodrow.
Thank you for the question. I think that's mostly with respect to the rebuttable presumption on the brandishing. Otherwise, I believe you would have to come in on, my understanding is you'd have to come in on a preponderance of the evidence, and really on a TRO, you have to show, other things, irreparable harm, balance of the equities, all of those things as well. So I think it's just on the presumption piece that I would read it that way. Otherwise, I don't read this as a strict liability statute.
All right. Representative Bottoms.
Thank you, Chair. So in the presumption section, you have carries a visible firearm, imitation firearm, or toy firearm. Why did you just choose firearms? Why didn't you also choose like toy swords and things like that?
Representative Woodrow.
Yeah, I appreciate the question. I think if we had an issue in America, and this sort of, we can talk about this in the next bill today. If we had an issue with, mass, swording incidents, and my kids were doing active sword drills at their schools, I would understand the question better. But respectfully, Representative Bottoms, we do have a lot of shootings in America. And, I think when it comes to voter intimidation, there's a difference between what one can do with a firearm and what one can do with a sword. And so that's why I would consider it in there. But again, I understand that there is a Second Amendment right. And I know that many folks view it as deeply held and cherished. And so I'm certainly not trying to interfere with that. Again, these are already areas where you're not supposed to be having a firearm.
Representative Bottoms, follow up.
Yes, ma'am. Thank you. So knowing that this is already against the law, do you have any record of anybody shooting up a polling place?
Representative Woodrow.
I'd ask the expert and our witnesses to speak to that, but not offhand, and I hope we don't have any.
All right. Any further questions? Seeing none, thank you all so much. We're going to move into witness testimony. Representative Woodrow, I do have a number of folks in support as well as in opposition. Do you have a preference in terms of if we hear one group before the other, or if you want me to alternate panels?
Thank you for asking. If we could do support first.
Okay, great. Thank you all very much. For our first panel, I'd like to call up Martha Tierney, Allie Belknap, Hillary Rudy, and Clerk Amanda Gonzalez. And we'll give those folks just a minute to be pulled up online. In terms of who's on deck, we'll hear from Jasleen Singh, Holly Monkman, Megan Rains, and Kirsten Forsyth in our next panel. Okay. All right, let's start with Allie Belknap. Come off mute, and the floor is yours for 2 minutes.
Thank you, Madam Chair. My name is. Oh, I'm hearing myself back. Oh, okay, that's solved. My name is Allie Belknap, and I'm the Executive Director of Colorado Common Cause. We are a nonpartisan nonprofit organization that has worked in Colorado to advance the right to vote and make government more accessible and accountable. We're here today to ask the committee to vote yes on this bill. The freedom to vote is foundational to our democracy, and our legislature has repeatedly acted to protect voters and election workers in response to growing safety concerns. In 2022, Colorado passed the Vote Without Fear Act to prohibit open carry in polling places. Last year, we passed Senate Bill 131, which prohibits any carry of a firearm at polling places. This bill is the next important step in strengthening these protections, ensuring that the voting process is free from intimidation and fear. Unfortunately, over the last 10 years, we've seen a rise in violent rhetoric and armed intimidation at both protests and at polling places. The President of the United States has repeatedly called for armies of poll watchers to monitor the polls for him, and armed groups have activated to watch vote counting facilities and stand guard at poll sites. According to a survey by the Brennan Center, nearly 1 in 3 election officials feel unsafe because of their job, and nearly 1 in 5 listed threats to their lives as a job-related concern. Our election workers provide a vital service to our democracy, and they should not feel unsafe while doing their jobs. Colorado Common Cause leads a coalition that manages the state's largest nonpartisan voter protection program called Just Vote Colorado. Just Vote Colorado provides a voter hotline during early voting through Election Day that answers questions about where and how to vote and allows voters to report any issues. This past election, we also deployed hundreds of volunteers to be friendly faces at polling service centers, hand out food and beverages, and keep folks in line despite the weather. A major component of that is training them to spot and report intimidation at the polls. And in past years, we've had instances where a caller did report seeing a person with a firearm that caused them to feel unsafe. I know that I'm out of time, but we hope that you'll vote yes on the bill, and just know that any kind of firearm at a voting location can create fear and uncertainty among voters and election workers.
Thank you so much for your testimony today. I know 2 minutes goes so quickly. Let's move over now to Hillary Rudy. Please come off mute. Tell us who you represent, and the floor is yours for 2 minutes.
Thank you, Chair Wolford and members of the committee. I am Hillary Rudy with the Colorado Department of State, and I'm testifying today in support of House Bill 25-1225 on behalf of the department. I want to thank the sponsors, Representatives Woodrow and Velasco, for bringing this legislation. Most election officials would tell you that their jobs used to be relatively quiet, and they spent years tirelessly working to ensure that their local elections ran smoothly. But since 2020, reporters, federal law enforcement agencies, nonprofits, elected officials, and election officials themselves have been sounding the alarm regarding unprecedented threat environment that election officials have found themselves in. And unfortunately, that threat environment has had very real effects. Election workers have reported feeling frightened by the harassment that they and their colleagues receive. Over 30% of Colorado's election officials alone have turned over in the last 5 years. That means we have lost an untold amount of experienced, dedicated public servants due to intimidation. No one should have to worry about the safety of themselves or their families when serving as an election administrator or when attempting to vote. House Bill 25-1225 builds upon established criminal penalties for threatening or intimidating of individuals who are participating in our elections by allowing the victims to sue the perpetrator for equitable or just relief through a civil action. The additional liability of money damages could be an important and sometimes even more powerful deterrent to individuals intending to threaten an election worker. The department supports this legislation because protecting our election workers and officials, we safeguard our democracy. We must do all we can to protect and retain our top quality election administrators at the state, county, and local level. As the DOJ said, a threat to any election official, worker, or volunteer is at bottom a threat to democracy. The Secretary of State's office urges your support for this bill, and I thank the sponsors for bringing forward this legislation.
Right on time. Thank you so much, Ms. Rudy. Next, Clerk Amanda Gonzalez. Please come off mute, and the floor is yours for 2 minutes.
Thank you, Madam Chair, and thank you for the opportunity to testify in support of House Bill 1225. My name is Amanda Gonzalez, and I have the honor of serving as the Clerk and Recorder in Jefferson County. In this role, I've seen firsthand the importance of ensuring that every voter, election worker, and community member can participate in our democracy without fear of intimidation. At its core, this bill is about protecting the fundamental right to vote and ensuring the administration of elections remains secure and accessible to all. Voter intimidation, whether overt threats, coercion, has no place in our democracy, and threats that involve firearms are uniquely harmful and scary. It's already illegal to bring a firearm into a vote center in Colorado, but this bill addresses a broader concern: the presence of firearms or intimidation used to create a climate of fear around election activities. Our election workers, many of whom are friends and neighbors, deserve to do their jobs without being subject to intimidation. Likewise, voters should be able to cast their ballots without second guessing their safety. This bill does not infringe on a Second Amendment right. Instead, it provides reasonable safeguards to ensure the presence of firearms does not deter individuals from participating in the electoral process. It aligns with Colorado's longstanding commitment to secure, accessible, and intimidation-free elections. Before I decided to run for office, I was aware of these kinds of threats and actually made sure that I had somewhere else to stay if I needed it during an election. I decided to run for office because our democracy is worth it, but no election official should have to make that calculation. Thank you so much for your consideration of this bill, and I urge your support.
Thank you very much, Clerk Gonzalez. Committees, what questions do you have for this panel? Representative Bradley.
Thank you, Madam Chair. So I heard from the representative from the department. You said increased threat environment from election officials. And in the ledge deck, we have no specific evidence that a firearm was indicative of any of these examples. And we have a bill that's going to increase criminal penalties. So I was hoping you would give me statistical evidence. And then my second question is, 40% of local election officials have left. Is that termed out? Are they tired of elections? We are the most polarized state in the United States. I want you to finagle those statistics for me, because just saying 40% of local election officials in Colorado have left does not help me with those statistics.
Ms. Rudy.
Thank you, Madam Chair. Thank you for the question. If I could tackle those one at a time. First, this bill doesn't increase criminal penalties. Those criminal penalties already exist in the law. What this bill does is expand that protection to allow for civil penalties. And so, again, it doesn't increase criminal penalties. In terms of folks who have left the field across the country, individuals are leaving election administration due to the threat environment, also due to being termed out or retirements. Certainly that still exists. I don't have statistics at hand right now to give you a breakdown of that, but there are several surveys by nonprofit organizations that do provide a lot of information about the reasons that election officials are leaving, and threat environment is among the top reasons.
Follow up, Representative Bradley.
Thank you. I'm sorry. I thought you had said when I was writing down what you said that it increased criminal penalties. So my apologies. Again, I think we do a disservice when we say 40% of local election officials in Colorado have left their positions, kind of terming it because of threat, when we're saying that they're also termed out or left because of retirement. In the ledge deck, it has 4 different examples of different things. And I'm asking, are any of those examples due to a firearm?
Ms. Rudy.
Again, I don't have specific statistics at hand, and I'm not aware of any instance, at least in Colorado, where a firearm has been used in a polling place, at a drop box, or in an election official's office to do harm. What I'm aware of are, as has been testified to, individuals who have brandished firearms around drop boxes, and voters have reported feeling intimidated. I think that to assume that a firearm must be present in an election official's office for them to be intimidated by it, or that it must be used for them to be intimidated, is taking a step beyond what we're saying. Again, firearms are currently not allowed in these locations, and what this bill does is to extend civil penalties, which can be a larger deterrent in many cases. to these types of actions.
Representative Bradley, a follow-up.
This is my last question, and thank you for your answer. But you have no specific stats where that has been done. So you're saying that we need another bill to infer civil penalties for something that has not happened. Is that true?
Ms. Rudy.
Thank you, Madam Chair. And again, thank you for the question. Given that the threat environment is the largest reason that election officials cite as leaving their jobs currently, we also have to consider attracting new talent to the field in terms of asking folks to do this important work. People shouldn't feel afraid when they are running elections. People shouldn't feel afraid when they are doing their job as civil servants. It's not just about whether or not somebody has used a weapon in this fashion. It's about whether or not the individuals trying to do their jobs feel intimidated. And if we can't attract new talent to the field, and people are leaving the field because they are afraid for their jobs, for their lives, for doing their jobs, or they are afraid for their families' lives for doing their jobs, then yes, it's absolutely appropriate to increase the civil penalties around this.
Last question from Rep. Bradley.
I'm sorry, last question. But that could just be with their mouths or with a pocket knife or with anything could be used to intimidate. And if a firearm's not doing it, then how do we stop the intimidation? I guess that's my question. I mean, we're going to pass a bill, but you're sitting here saying there's no statistical evidence that a firearm's been doing it. We already have a statute that says that you can't have a gun with 100 feet of a polling place. You could, being intimidated could be someone screaming at you and saying, I hope you die. I mean, this bill is legislating guns. And so that's my question. It's already in statute to not do that. So that's my question. And actually, I don't even have a question. Thank you.
All right. Are there further questions for this panel? Representative Luck. And I just want to note we do have 4 minutes and 30 seconds left.
Thank you, Madam Chair. My question is also for the representative from the Secretary of State's office. I note that the fiscal note doesn't contemplate any additional dollars going towards the implementation of this policy, and yet this policy does give the authority to the AG as well as to the Secretary of State's office and any election official or designated election official to bring suit. And so presumably if this is such a big problem, there should be some sort of fiscal impact. I would think that the Secretary of State's office, if they're wanting to combat what they see as this intimidating threat such that people leave doing elections, that they would want to utilize this additional power in order to bring some sort of suit. So I'm just wondering what your thoughts are as to why there's not a fiscal note, why there is a thought that this won't actually be such an issue to require additional funds be given for the legal costs associated with that. And along those lines also, I am just wondering, well, I think I'll leave it at that for now, maybe.
Ms. Rudy.
Thank you, Madam Chair, and thank you for the question. With respect to our fiscal note on this bill, the unknown factor of whether there would be litigation or not makes it entirely speculative, and it is the department's practice not to include speculative costs in fiscal notes.
Representative Luck for a follow-up.
Thank you, Madam Chair, and I appreciate that. But I would think that if this is such an egregious situation that needs us to intervene in this way, that the current law is insufficient to provide the necessary protection for voters and election workers, that we would have enough instances that are confirmed, not just folks calling a hotline, but actual confirmed instances such that you could build not, I mean, every fiscal note is subjective, and I would, maybe that's why supplementals are such a mess at times, because nobody wants to speculate until the dollars come back in. But I would think that you would have enough of a record to build a reasonable expectation.
Ms. Rudy.
with respect to legal costs in particular, it is highly speculative to include those in a fiscal note, even if there is substantial documentation. And again, it is our practice not to include speculative costs in a fiscal note.
Representative Luck.
Thank you. And it will be really quick so I can give over to Representative Espinoza. You said there is substantive information. I'd like to know how many cases you have that are Colorado specific over the last 4 years that have to do with intimidation, specifically as relates to intimidation with a firearm that has been substantiated, not just somebody called in and said.
Ms.
have a
Rudy.
concern.
Thank you, Madam Chair, and I apologize if I didn't succinctly articulate my response. I said that it is our practice not to include speculative costs in a fiscal note, even where there is substantial evidence. As I've already said, I do not have statistics readily available, and I am not aware of a specific instance where a firearm has been used in these instances.
All right, thank you. We have 20 seconds left on this panel. Representative Espinoza.
Thank you. I just have a question, Madam Chair, for the Secretary of State's office. And I just want to know, your office doesn't handle litigation. That would be within the Office of the Attorney General. Isn't that correct?
Ms. Rudy.
Thank you, Madam Chair, and thank you for the question. Yes, that is correct.
Okay, we'll start with this side of the room for our next panel questions. But thank you very much, witnesses, for your testimony today. We're going to move to the next panel, which is Jasleen Singh, Holly Monkman, Megan Rains, and Kirsten Forsyth. And then for anybody who may be listening, our next panel will be Allison Anderman, Allison Shai, Jesse Ojeda, and Carly Copes. All right. Welcome. We're going to start with you here on the end. Please state your name, who you represent, and the floor is yours for 2 minutes.
Great. Hi, thank you, Chair Wilford, Vice Chair Clifford, members of the committee. I'm Holly Monkman here on behalf of the League of Women Voters of Colorado. We support HB 251225. Since 1920, the League of Women Voters has been a grassroots organization whose members believe that we all play a critical role in our democracy. The League has always worked to promote the values and processes of representative government, protecting and enhancing voting rights for all Americans, assuring opportunities for citizen participation, and working for open, accountable, representative, and responsive government at every level all reflect our deeply held convictions. We've already heard from the bill sponsor regarding election worker turnover and the threats that our election workers and elected election officials have been subjected to. Intimidation tactics only serve to undermine the open, accountable, representative, and responsive government that we all want to have. No one wants an armed person on their front step inquiring about their vote, and no election worker or election official should have to worry about armed people gathering at their home. It's unfortunate that this bill is necessary. Thank you for the opportunity to testify, and the League supports this bill. Thank you.
Thank you so much for your brief testimony. Ms. Rains.
Good afternoon, Madam Chair and honorable members of the committee. My name is Megan Rains. I am the Director of Government Affairs for the Colorado Education Association, representing 40,000 educators across Colorado. And I'm here today to express CA's support for HB 251225, a crucial piece of legislation that will help protect the integrity of our elections by ensuring that election workers and voters can participate in our democracy free from threats and intimidation. In recent years, election workers have faced an alarming rise in threats simply for doing their jobs. These dedicated individuals are instrumental in upholding our democratic process, and they deserve the protections that 1225 provides. By allowing election workers to pursue civil action against those who threaten or intimidate them, this bill sends a clear message. Threats against those administering our elections will not be tolerated. A healthy democracy depends on the ability of every voter to cast their ballot without fear. Every year, educators participate in the political process, whether knocking on doors, assisting in others in voting, or simply showing up to the polls. Every individual deserves to feel safe while participating in the democratic process. By strengthening protections against election-related threats and intimidation, 1225 helps preserve grassroots engagement and protects access to the ballot for educators and all Coloradans. Colorado is already a national leader in voter turnout, and the legislation will further solidify our state's commitment to protecting access to free and fair elections. Ensuring that individuals can seek damages when their right to vote is threatened is a crucial step in maintaining trust in our electoral system. I urge the committee to support HB 25-1225 and take this important step towards protecting our elections and the people who make them possible. Thank you for your time.
Thank you very much. Next up, Ms. Kirsten Forseth.
Hi there, my name is Kirsten Forseth, and I'm here representing the Colorado AFL-CIO. The AFL-CIO is heavily involved in getting out the votes of voters who typically do not turn out. Unfortunately, there has been a call lately by candidates to attack people administering elections, voters, as well as people assisting with helping individuals get out and vote. These underhanded and sometimes violent attacks are prohibited against election workers, but this bill expands those protections. HB 1225 provides the ability for an aggrieved party to sue or get a restraining order. It also provides a presumption of intimidation if a firearm is involved in a person engaging in election activities. The Colorado AFL supports and the Colorado AFL and its 185 affiliates support policies that protect our elections and help voters feel comfortable with exercising their right to vote. Keeping it short.
I'm loving this. Thank you so much. Let's go online to Jasleen Singh. Welcome.
Good afternoon, Chair and members of the committee. My name is Jasleen Singh, and I'm an attorney at the Brennan Center for Justice, NYU School of Law, a nonpartisan organization dedicated to protecting and strengthening democracy. I'm here today to offer our support for HB 25-1225, the Freedom from Intimidation in Elections Act. The threat of intimidation in our elections has existed for as long as our country has held elections. Over the years, what that intimidation looks like has evolved. But each time that has happened, lawmakers like yourselves have stepped up to confront the problem. During the Reconstruction era, for example, intimidation took the form of the KKK terrorizing Black voters and their allies. In response, Congress stepped up to pass the Klan Act in 1871. Nearly 100 years later, intimidation took the form of literacy tests and poll taxes that disenfranchised Black Americans and violence against voters and voting rights activists. In response, Congress passed the Federal Voting Rights Act of 1965. Now, we face a new threat to our election system, an effort to discredit American elections and the people who run them. And once again, it has led to a new form of intimidation. Widespread allegations of unproven fraud are driving violence and threats directed at election officials, poll workers, and voters. Colorado has already taken steps to address these threats by passing legislation to prohibit firearms at polling locations, counting facilities, and near drop boxes in 2022 and 2024. This legislature has also passed the Protections for Elections Officials Act in 2022. Today, I ask you to follow in the footsteps of our forebears and this very legislature by passing HB 1225, which would make significant and further strides towards addressing this new threat. In Colorado, like all states, it is a crime to intimidate a voter or election worker. Yet only 6 states allow voters to sue for damages, and only 2 allow election workers to do so. Private enforcement is very effective at deterring bad behavior, and what better use of it than safeguarding our democracy? Colorado can join a handful of states leading the nation by taking this important step.
Thank you so very much for your testimony.
I respectfully ask your vote. Thank you.
Okay, great. Thank you very much. Committee, what questions do you have for this panel? We're going to start on this side. Nothing. Okay. How about on this side? Oh, I was going to shoot for nothing, but all right, Rep. Luck.
Thank you, Madam Chair. My question is for the representative from CEA. So on page 5, the subsection 3 talks about an individual, whether acting under color of law or otherwise, shall not intimidate, threaten, or coerce, or attempt to intimidate, threaten, or coerce any individual for any of the following as relates to voting. I know that there are a number of instances, some that have even gone through the court system, wherein a teacher has mandated as part of a class that a student or set of students participate in the civic process and propose or promote particular ideas that are contrary to the ones that they share. Would you be supportive of this bill being used against teachers who may intimidate, threaten, or coerce their conservative students to vote a particular way in more liberal settings, or their liberal students to vote a particular way in their more conservative schools?
Ms. Rains.
Thank you, Madam Chair, and Representative Luck. I don't know of any specific examples where that has happened, so I don't feel like I can speak to that today.
Representative Luck.
Thank you, Madam Chair. And I appreciate that you may not know of specific examples, but join me in the hypothetical realm. And if there was a situation where a teacher said your final grade is dependent upon you voting, not voting, voting this way, not voting that way, otherwise seeking to intimidate, threaten, or coerce a student to participate or not participate in the act of voting, would you be supportive of this law being used against teachers in that way?
Ms. Rains.
Thank you again, Representative Luck. So I'm hesitant to go with you down this hypothetical lane because I have not heard of this happening. I don't know specific examples, but generally I'm supportive of educators and their districts coming together and agreeing upon appropriate contract provisions where those things are laid out. So I would leave that up to districts to determine what is and is not appropriate for their educators to discuss the political process with their students.
Representative Bradley.
Thank you, Madam Chair. I'm going to ask you to ask this other panel because we haven't heard any confirmed cases of this either, of voter intimidation with a firearm. So I'm just wondering if you guys do, since you don't have any, what Rep. Luck was just bringing up, just wondering if you have any voter intimidation with use of a firearm. Since you're quoting statistics, I just want you to give me some statistical evidence. Confirmed, substantiated.
Ms. Forsyth. Sorry.
I will say that there isn't like a central database. There isn't a place where all of this is reported, which is why you are hearing kind of anecdotal responses here. I have worked on many campaigns, worked on them for 20 years. There was one where we did have a line of people showing up with semi-automatic weapons at a polling place. It did have the profound effect of intimidating people away from that polling center. This was in 2013 during the gun recalls. So you can imagine why this was happening. So yes, I have stories, but there is no central place right now where we are reporting voter intimidation.
Representative Bradley.
Thank you. Reported in the paper, reported to law enforcement. There's a police report.
At the time it was reported to law enforcement, but I don't know that that has been like pooled anywhere. They're required to keep that data and report out to anybody.
Representative Bradley.
Could you send that to me? Rep.
Sure.
Bradley at Gmail. Thank you.
Sure.
All right. Representative Luck.
Thank you, Madam Chair. And just following up on that, so was that during the time of 2020, like after the 2022 bill passed, such that, oh, it was in 2013, I missed that.
2013.
Okay, so since 2013, we don't have any examples of this, especially since 2022 when this bill was already passed to protect this space in this way?
Ms. Forsyth.
For good or for bad, I now work inside the building and don't work as much on campaigns. So I think people who have more experience with that would be able to answer those questions. But I have heard evidence of these situations happening since then.
Okay. Thank you all so much for your testimony today. We're going to move now to our last support panel. Allison Anderman, Allison Shai, Jesse Ojeda, and then Carly Coops. And while we wait for people to be called up online, our next panel will be Keith Emerson, Catching Valentis, Seth Stern, Gregory Collins, and Candy Boyer. All right, let's start with Allison Anderman. Please come off mute, and the floor is yours for 2 minutes.
Good afternoon, Madam Chair and members of the committee. My name is Allison Anderman, and I am an attorney consultant for the Brennan Center for Justice. I am here in support of HB 25-1225. In 2022 and 2024, this legislature wisely banned guns around places where elections are happening. This went a long way towards making elections safer from violence and intimidation. In doing so, Colorado joined Arizona, Florida, Georgia, Louisiana, Texas, and several other states that long ago recognized that guns can and have been used to intimidate voters. This bill adds on to those protections by giving voters and election workers civil remedies for intimidation. The bill also presumes that a person carrying a visible firearm around voters or election administrators is intimidating. This presumption is based on the same rationale that led the legislature to ban guns around elections. Guns are intimidating, and as many gun rights advocates will tell you, they are meant to be. The Supreme Court has acknowledged this fact in the Bruin and Heller decisions when it said that banning guns at polling places was presumptively constitutional. Nevertheless, this presumption, like all other presumptions in our laws, can be rebutted. A person can show that based on the circumstances, it was not reasonable for the voter or election worker to have felt intimidated. Everyone has the constitutional right to opine on our elections, but they do not have the right to threaten or intimidate people who are voting or serving their country as an official or worker. And they certainly do not have the right to do so with a gun. This bill creates additional civil deterrence to this type of intimidation to make sure that voting is free and safe. Thank you, Reps Woodrow and Velasco, for introducing this bill, and thank you for the members of the committee for your consideration. I respectfully ask for your aye vote.
Thank you very much. Next up, Allison Shee.
Good afternoon. I'm Allison Shee, Senior Counsel at Everytown for Gun Safety. Thank you for allowing me to testify today in support of HB 1225. This bill would protect election workers and voters from political violence and intimidation. Violent extremists seeking to undermine our democratic institutions are a chronic and ongoing problem. On their own, threats and acts of intimidation are harmful to our democratic institutions. And with every threat, there is a risk of escalation to physical violence. In addition to those mentioned by Representative Woodrow, here's a sampling of threats against election officials that have occurred in our country in recent years. In 2022, a Republican election commissioner in Philadelphia began experiencing harassment about a week before the interim elections. He and his fellow commissioners received a voice message stating that they were the reason we have the Second Amendment. Just after the election, police arrested 2 men outside the vote counting center armed with several guns, including an AR-15 style firearm. In the weeks that followed, Schmidt and his family received a slew of threats. Even his wife received an email with multiple threats, including one stated that Albert Rhino Schmidt will be fatally shot. Race-based harassment of election workers has also become all too common. In Fulton County, Georgia, a registration chief who's a Black man received a threat calling him a racial slur who should be shot. He was also told that he would be dragged around by a truck until he died. In Detroit, a city clerk who is a Black woman received a report from authorities that a white supremacist was making death threats against her. And in Broward County, Florida, a supervisor of elections who is Black received many threats, including an email that used a racial slur and called him subhuman. Political violence and threats of armed extremism are never acceptable in an advanced society, and we must continue to innovate ways to prevent it, especially when threats and intimidation are driving election officials out of the profession. And we have to do everything we can to prevent threats and intimidation from escalating to physical violence. HB 1225 adds another tool to the toolbox of ways to protect voters and election workers, and in turn, our elections. I urge you to vote yes.
Thank you very much. Next up, Jesse Ojeda.
Good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to speak today. I'm representing the Giffords Law Center, where I lead our Guns and Democracy program, which focuses on the rising threat of armed violence and extremism in this country. I'm here to express our strong support for HB 1225. This bill directly addresses growing threats against our voters and critical election workers by strengthening anti-intimidation laws and empowering those impacted by such to directly seek civil recourse, including damages and injunctions, remedies that would otherwise require costly state intervention. This bill is unique from recent efforts to protect our election workers in that it has the potential to extend intimidation safeguards beyond the immediate vicinity of threats made at polling places, which is critical in an age when social media, email, and text make it easier than ever to acquire private information and target these workers beyond their jobs. However, I want to be clear, this is a narrowly tailored protection that applies only to specific election-related activities, not a broad restriction on open or concealed carry. There are two examples I can offer of the type of situation where this bill would apply. The first relates to the incidents from Maricopa County, Arizona, where in 2022, a group of openly armed persons dressed in tactical gear strategically placed themselves just outside of the state's polling place perimeter, leading to numerous calls from concerned voters. This case ultimately required a court intervention. Another is that of Michigan Secretary of State Jocelyn Benson, who in 2020, while decorating her family Christmas tree with her young child, experienced a group of armed protesters show up to her home to protest her COVID-19 election protocols. Unfortunately, underreporting and privacy concerns limit us from having a comprehensive list of every incident, but anecdotal and research-based evidence confirms that these threats are real. We also anticipate that this law will have a strong deterrent effect through the creation of the civil remedies. Colorado has long been a leader in election security and voter access. HB 1225 simply builds on this foundation. I urge you to support this important legislation. Thank you.
Thank you very much. And can you state your name for the record, please?
Oh, yes, apologies. It's Jessie Ojeda.
Great, thank you. Next up, we have Carly Coppes, and I believe you might be here for questions only, but if I'm wrong, please feel free to share your testimony.
Thank you so much. I am Clerk Carly Coppes from Will County, and I am here for questions only at this time. Thank you.
Thank you very much. Members, what questions do you have? Representative Luck.
Thank you, Madam Chair. And I believe it was the second person who spoke, but I didn't catch the name. Allison Shee. Thank you. This question's for you. Forgive me, I was taking some notes, but you were mentioning our democracy requires this. Is that right? Was that part of your testimony, or is that the first person who testified?
Ms. Shee.
My testimony is that a healthy democracy requires we do everything that we can to reduce the chances of intimidation and reduce the chances of violence around our electoral and democratic processes.
Okay, thank you. I have two questions for you. The first, the examples that you gave, I didn't hear any of them as relates to Colorado. Do you have any examples for Colorado specifically?
Ms. Shee.
I do. Thank you. Sorry, Chair. I do. And many of them were discussed by Representative Woodrow. What I wanted to give was a sampling of incidents around the country that I imagine that you all want to avoid happening in Colorado, and give an opportunity for not to look like what happened in Philadelphia, like what has happened in Detroit, like what has happened in Florida. These are instructive, and I imagine especially you all as elected officials want to do everything in your power to avoid that happening in Colorado, and not just be reactive to a tragic situation and a stressful situation for anybody in the state of Colorado, whether they're exercising their right to vote, or it's a person who's performing their duty as an election official.
Okay,
Representative Luck.
Thank you, Madam Chair. So Representative Woodrow had outlined the 4 examples that are in the legislative declaration. Are those the 4 that are those the examples that you're pointing to?
Ms. Shee.
Yes, those are the 4 I know off the top of my head, and I defer to my colleague on this panel, Allison Anderman, who may know of others, or if there are supplemental ones, and may know of them more in detail.
Okay, thank you. And then my question also, do you by chance say the Pledge of Allegiance at the beginning of different events?
Ms. Shi.
Not sure that's relevant, but of course I do. And I'm a proud daughter of a veteran who served this country, a disabled Vietnam veteran. I am very much a proud American. I love this country and have sought my entire life to serve it. And that's why I do the job that I do.
Representative Luck.
Thank you, Madam Chair, and I appreciate that answer. That's great to hear. The reason that I bring it up is because I think it's important for us as we dialogue about these different issues and frame them to remember that we are in a republic, a constitutional republic, that we don't live under democratic mob rule. Thank you.
All right, any further questions? Seeing none, thank you so much to this panel for your testimony today. All right, our next panel is an opposition panel, so we'll call Keith Emerson, Catching Valentis, Seth Stern, Gregory Collins, and Candy Bauer. And then our last panel after this one will be Alan Fisher, Brian Cordell, Ronald Dietz, Ava Flanell, and Heather Stauffer. All right, we will start with you, sir, in the red. Please introduce yourself and the floor is yours for 2 minutes.
My name is Keith Emerson. I'm a retired professional engineer and I'm not representing anybody but myself. Let's get real. This is a gun bill. This isn't about somebody sending an threatening email. This is about doing something when you're open carrying. This bill makes no sense. What it tries to make illegal is already illegal, except where it attempts to criminalize free speech. Please postpone this bill indefinitely. Personally, I find open carry of firearms comforting, but I realize that some people see all firearms as a personal threat. That said, open carry of firearm is legally permitted in most areas of the state. As far as placing a bubble around everyone associated with elections everywhere, talking with someone while legally open carrying a firearm is not illegal and shouldn't be. Carrying is not brandishing. And importantly, intimidation with a firearm, which some call brandishing, is already covered by Colorado law in 2 places. The big one is menacing, which is person commits a crime of menacing if by any threat or physical action he or she knowingly places or attempts to place another person in fear of imminent serious bodily injury. Menacing is a Class 1 misdemeanor, but is a Class 5 felony if committed by the use of a firearm. Toward the end of this bill, it states that to prevail in a suit to enforce subsection 3 of this section, a plaintiff is not required to prove that a defendant intended to intimidate, threaten, or coerce an individual, except to prove an attempt. One would hope this would be considered in light of the First Amendment and allowed free speech. This bill is an affront to the First Amendment. Please postpone HB 25-1225 indefinitely. I was hoping to have time to go into cause versus causation, but I don't.
Thank you very much for your testimony. Sir, please introduce yourself and the floor is yours for 2 minutes.
Thank you, Madam Chair, committee. My name is Catching Valentinus with Rocky Mountain Gun Owners, and this bill is an affront to the First and Second Amendment. It's clear that this bill seeks to make polling places a more dangerous place and effectively works to marginalize and shame those citizens in Colorado who open carry for the safety of their family and their community. It's not the law-abiding citizens that open carry that are a threat to elections. It's the criminals who seek to brandish their weapon and menace those at the polls. This law goes too far in a variety of different ways. It is certainly duplicative. And I'd like to highlight the canvasser measure. Canvassers are door knockers. In this bill, you cannot go to someone's door or you cannot answer your door with someone knocking it during an election while you're open carrying inside your own house, unless there's some sort of exception. The toy gun imitation firearm measures of this bill are silly. And again, they are fear-mongering in this great free state of ours. That is the only reason why they're in this bill. By the way, happy St. Patty's Day. I see that most people wore their green. I think you might have some hiding. So I brought my little 4-leaf clover, but I also brought a water gun that carries my green. So this gun is not intimidating. It is banned by the bill, but it will do no harm to anyone, cannot. But for some reason, the language is still banning it. This gun can do no more harm to someone than the gun of a law-abiding gun owner. I encourage you to vote against this bill. Thank you.
Thank you very much, Mr. Valentis. For future reference, we're not going to do that again with props, but we're going to go online to Candy Boyer now. Thank you. Please come off mute, introduce yourself, and the floor is yours for 2 minutes.
Sorry about that. Good afternoon. My name is Candy Boyer, and I am here testifying today on behalf of myself and other election workers. I've been an election judge since 2017. I was a participant in that election recount in El Paso County of 2022. And I will give you some personal examples of intimidation that occurred during that recount. There was a person using a camera with a 3-foot lens to photograph ballots through the window. Pieces of paper and posters were held up against the glass. Some of the candidates and their watchers in the room were distracting, and their actions could be construed to be intimidating. There were other things going on in the hallway that was disruptive to the whole process as well. It was overall not a pleasant experience and should not have devolved to that level. While I appreciate people's desire to protest, the level of respect was very sad. On the flip side of that, I believe in the Second Amendment rights granted to us. I do not currently own firearms. I have an issue with the language in this bill. Brandishing has come up many times in this discussion. That is not what the bill says. It's also a presumption of guilt before innocence. I ask that you vote no on this bill as it's currently written. Thank you.
Thank you very much. Members, what questions do we have for this panel? Representative Bottoms.
Thank you, Chair. Mr. Emerson, I have an email from you. And it looks like you didn't get to finish it. Would you like to talk about the causation subject?
Actually, instead of finishing your testimony, I'm going to have you speak directly to his question, okay? He was asking about causation.
Yes. Actually, I wanted to put a little humor into this and mention cause versus causation, which is something everybody here needs to think about when they hear these examples thrown out. Okay. People wear sunscreen in the summer. There are more shark attacks on people in the summer. Therefore, sunscreen causes shark attacks. That's cause versus causation. Don't get confused between the two. Just because there have been a lot of incidents, as Representative Bradley said, look at the actual statistics underneath it. Thank you. Thank you for your question.
All right, Representative Carter. Go ahead and turn on your mic.
I guess this question is for Mr. Valentino. If you can
Valentinus, but thank you.
Valentinus, I'm sorry. I apologize, sir. If you can expound on your concept of canvassing and how it would relate to this bill.
Yes, sir.
Mr. Valentinus, just a minute, okay? Did you finish your question?
Yes.
Okay, all right, you can respond now.
Thank you, Madam Chair. Thank you, Mr. Representative. So at least my last read through of the bill, I saw canvassing in there. Canvassers can be paid or volunteer. It is typical that they go to someone's front door to ask them either about certain questions that are relative to an election, or simply ask someone, whoever answers the door, to vote for a particular candidate. Right now in the bill, open carry, even on your own property, would be criminalized.
Did you want to follow up, Representative Carter?
No, Madam Chair.
Okay. All right. I'm not seeing any other questions, so thank you all so much for your testimony today. Our last panel will include Alan Fisher, Brian Cordell, Ronald Dietz, Ava Flanell, and Heather Stauffer in an amend position. Yes, please come and collect your prop. That should not come back to committee. Thank you.
We don't let anybody use props for anything.
And also, if there is anybody else that wishes to provide testimony either in favor or in opposition to the bill, come forward at this time. Ms. Stauffer, would you like to proceed?
Thank you, Madam Chair. Thank you, members of the committee. My name is Heather Stauffer. I'm here on behalf of the Colorado Municipal League. We are in a friendly amend position on this bill. In a democracy, the integrity of our elections is not just about preventing fraud. It is also about ensuring that every eligible voter can participate freely and confidently. Ensuring safe and intimidation-free elections requires us to enforce strong protections against voter harassment at polling places, ensuring protection for election workers, and providing clear legal consequences for those who attempt to interfere with a citizen's right to vote. We believe that House Bill 1225 accomplishes these objectives. We are looking at the bill from an implementation standpoint, and there are a few areas that we feel need to be clarified. I believe that the amendments forthcoming today will clarify several of our concerns, and we will look forward to working with the bill sponsors to fine-tune the language to ensure that our police officers working in their official capacity can continue without fear of being implicated in a lawsuit. So we are in a friendly amend position, and I'm happy to answer any questions.
Thank you very much. Let's go online. All right, let's hear from you, Ms. Flanell. Introduce yourself and the floor is yours for 2 minutes.
My name is Ava Flanell. I'm the Vice President of Legislative Engagement for Colorado State Shooting Association. If legislators are going to determine to pass this misguided bill, then it's only fair that Colorado citizens be granted constitutional carry, ensuring that they are not forced to open carry their firearms. However, that bill was killed by this exact committee a few weeks ago. Since the passage of HB 24-1174, the Concealed Carry Requirements Bill, my county now takes approximately 8 months to issue a concealed carry permit. This excessive delay forces many individuals to choose between unlawfully carrying concealed without a permit or open carrying their firearm. No citizen should have to decide between personal safety and exercising their right to political discourse. Furthermore, individuals should not live in fear of being accused of intimidation simply because their lawful firearm possession offends those who oppose the Second Amendment. Moreover, this legislation infringes upon both First and Second Amendment rights. Lawmakers have neither the authority nor the right to dictate what individuals can discuss. Likewise, they should not restrict a person's ability to protect themselves, especially when engaging in activities such as knocking on a stranger's door, inquiring if they're going to vote or not. Lastly, since we live in a mail-in ballot state, this would literally bar someone from voting in their home if they happen to have a gun on their hip and want to ask their family member how they plan to vote. That's how ridiculous this bill is. Make the right decision and stop attacking law-abiding citizens.
Thank you so much, Ms. Flanell. We're going to go now to, I think, Ms. Garcia. Come off mute.
Yes,
The
thank
floor is
you.
yours.
Can you hear me okay?
Yes, we can hear you. Please proceed with your testimony. Please also ensure that you're being
I want to
safe.
I want to thank all my white saviors arguing for colored people to be able to not be intimidated at the polling places that don't have any representation in this community other than what they're being told to think. So let's take it back to why firearms are so important in polling places in the first place. Do you know what the first group in America was that was the first domestic terrorist group that wanted to prohibit gun owners from being able to vote? It's the KKK. And they wanted the monopoly on violence because the Republican Party wanted to give socio-political and economic equality to people of color. So they could vote, so they could exercise their right to speak out on the things that are affecting them in their lives. So the KKK, being the white supremacists that they are, I love hearing that people are championing that. They're saying things like, oh, without the fear of intimidation, guns stop the fear of intimidation, because you know what they do? They make sure you can't proceed with your intimidation. They give you the right to say no. And the ability to vote is a human right, and it's a natural right for America. So is the right to bear arms. So what this is really doing is causing propaganda, telling people that they believe that the sheer presence of a firearm means that we are intimidating and we are dangerous. However, all these testimonies that I'm hearing from these people, it is not my gun that I am happily, openly carrying right now in my car. It is your fear and your rhetoric and your propaganda that you're pushing that is the fear and the intimidation to people like me exercising their constitutional rights. So as you sit here and advocate for historically racist laws, remind yourself of that, because you all need a history lesson. And thank you, Stephanie, for reminding people that this is a constitutional republic.
Thank you very
Thank
much
you.
for your testimony. Sir, please introduce yourself, and the floor is yours for 2 minutes.
My name is Kellen Lanier, and I am a neutral amend, mostly with questions here. So I don't have a speech this time, but my background is in human behavior, to shorten it up here. So in reading the bill, I have questions around safeguards. So what safeguards are in place to ensure that this bill doesn't create some sort of mechanism to weaponize, perception for partisan goals? That's a really big concern of mine here, and specifically, I'm talking about kind of a signaling effect, via just priming people to see this bill and think that they are intimidated by mere presence. That's a concern of mine. Other than that, I don't really have much. That seems like a really big gaping hole in this thing that could kind of derail the stated intent from what I've heard here.
Thank you very much. Committee, what questions do you have for this panel? Vice Chair Clifford.
Mr. Lanier, is that right? Do you feel like the undertones of this bill are racist?
Mr. Lanier.
It has, like I said in my very brief testimony, I think it has the potential to be wielded that way because it is essentially a weapon, and I feel like it could go either way. Whichever party is in power could utilize this towards their own ends. So in its current stance, I'm inclined to believe yes, but that's not inherent in the bill. That's the people signaling behind it.
Did you have a follow-up? All right, yeah. Vice Chair Clifford.
Thank you. The second question, and it's clear that this bill doesn't change anything about the law of whether or not someone can open carry at a polling place. That's not up for debate. What is up for debate today, and what we're engaged with today specifically, is whether or not you should be able to ask a court to enter an injunction when you have felt threatened at a polling place or at a ballot box. Is that clear to you as we look at this? And does that change anything about your previous answer?
Mr. Lanier.
That may sound like that sounds like a question for Ms. Garcia. That was more of hers. I was neutral, just to remind you.
Yes.
You know, but in attempting to answer your question, it doesn't change it only because of the current environment. Again, I see this as a thing that is left wide open and very vulnerable to social manipulation. So in that way, I it doesn't really change much. I do understand, you know, the intent of the bill. It seems very vulnerable.
Thank you. That's just particular. Oh, my sorry.
Go ahead, Vice Chair Clifford.
That's particularly what I'm engaged with right now. And I haven't decided whether I think there's a need for this, because we just passed a bill, a law 2 years ago that made this illegal to have a gun in a polling place publicly displayed. You know, but that's the thing for me that's the crux today, is that what we're debating here is whether or not the actionable access to remedy was appropriate, to have that only be law enforcement, and to have someone become law enforcement engaged should they be at a polling place with a firearm. And the premise of this bill is that there would be the opportunity for a civil action as well. Mr. Woodrow specified that it was because law enforcement is busy. I also have a view that it's not always best to have people just necessarily become law enforcement engaged, charged with crimes for something like this. That's the nature that I'm leaning on. So from that premise, do you have any feedback?
Mr. Lanier, I'm sorry.
And thank you.
You know, in that case, then, you know, I would be inclined to believe that this is an unnecessary bill. You know, if it, from what I've heard earlier, it sounds entirely redundant. And it sounds like that's what you're saying. Like there are already things there. So that brings me back to that question of why. You know, if there are already things, then why are we spending time talking about this one? And I have to question the intent of the bill at that point, given all of the other things it leaves open. So
no further. Thank you.
Representative Bradley.
Thank you, Madam Chair. And Mr. Lanier, always a pleasure to have you here. You open my mind up to a lot of different things, but I think I would disagree. We've had no statistical evidence that this has happened with the use of a firearm here. We do have statute 2 years ago, but I think I'd like you to comment on something that doesn't have to do with the firearm at all. It's on one page of the bill that an individual, whether acting under color of law or otherwise, shall not intimidate, threaten, or coerce, or attempt to intimidate, threaten, or coerce any individual for any of the following: voting or attempting to vote, urging or aiding any individual to vote or an attempt to vote, whether as part of official election administration activity or otherwise. That has nothing to do with a gun. That is First Amendment. And so I'd like maybe for you, because that I think is what you're speaking about. So maybe I'd like you to expand on that.
Mr. Lanier.
Ooh, lots of words. I think that goes back to my original premise. You know, I don't even think I mentioned guns in my, I think you guys just associate with me with guns now. But yeah, I think that there are First Amendment issues with that as well. But still, I cannot get over the fact that we're allowing people who may be in an acute stress situation to then skip some of the due process and be like, oh, I was afraid. That's where we get to the racist part. You know, and again, is that inherently racist? No, but can it get somebody there a lot quicker and with damaging effect? I do think so.
All right. I'm not seeing any other hands, so thank you to these witnesses for your testimony today. All right, last call. If there's anybody else that wishes to provide testimony on this bill, now is your time to shine. All right, I'm not seeing anybody put their hand up, so the testimony phase is now closed. Bill sponsors, please join us up here for amendments. And members, I do want to acknowledge that amendments L001 and L002 have already been passed out, so you should have those available to you. Did you want to proceed with L1? We can move it and then you can talk about it?
Yes, that'd be great.
All right, Vice Chair Clifford.
Madam Chair, I move L001 to House Bill 1225.
All right, that's been seconded by Representative Espinoza. Representative Woodrow, tell us about the amendment.
Sure. Thank you, committee. L001 clarifies that the firearm presumption does not apply to law enforcement when acting in their official duties or uniformed security employed by a security agency acting within that scope of authority when providing security to the polling place. Several folks in the stakeholder process asked for this, and we were amenable to it. I think it makes sense. We'd ask for an aye vote.
All right, any questions or comments, committee? Representative Luck.
Thank you, Madam Chair. So I do have a question. When we had a conversation earlier, your assurances to me were that that this open carrying, that the simple act of open carrying, because of the guardrails and protections of the court system, were such that that added that plus the rebuttability of this presumption would protect the average guy. And yet here we're giving special treatment to classes of people who openly carry and so I'm just trying to square this in my head. If in the bill sponsor's idea, the ability to just open carry can be easily overcome by some showing of the fact that it's not intimidating, why give this special protection to them, especially since you're not giving it to them vis-a-vis the words that come out of their mouth, i.e. in Section 3?
Representative Woodrow.
Yeah, so we're exempting law enforcement, which, you know, oftentimes on various bills, we make carve-outs for law enforcement. Also, we understand that there might be security that's hired to work there, and we wouldn't want them covered by the bill either. And I would also note that, like some folks have already said repeatedly, we're not supposed to have firearms in polling locations. So, you know, what we're trying to do here is, you know, make it clear that law enforcement, them carrying is not, you know, on the same level as someone else. And I would think that that's something we can all get on board with.
Representative Luck.
Thank you, Madam Chair. So again, we're saying that a law enforcement officer can intimidate someone through what they say, but that the presumption of carrying a firearm is not, they're not going to be held to that same standard of intimidation simply because that's presumably an aspect of their job vis-a-vis the polling location. But as has been testified to, this bill applies to much more than just a polling location. And so what I'm actually hearing is that something different than what was testified to or supported in the opening set of questions related to presumption and the ability to rebut, such that I'm still left with confusion as to the bill sponsor's intention here and why to give this carve out, as opposed to if it's easy to rebut the presumption, as was stated before, then why not just have these guys also rebut that presumption? If we're not concerned about, you know, non-intimidating actions being roped up in this, simply just carrying a gun, you know, not that there has to be more than just that, because that's what was discussed in the opening, then again, why would we need to carve out the law enforcement? If the aforementioned was true, then why do we need this, I guess is what I'm asking.
Representative Woodrow.
Yeah, sure. I appreciate the question. At the same time, the presumption that's created is with respect to intimidation. No one should be intimidating anyone at a polling location. And with respect to law enforcement, you said it yourself, it's part of their job that they open carry. So they shouldn't be wrapped up or have to deal with the presumption that we're creating for folks whose job it is not to open carry in a law enforcement and public safety capacity. So I do think that there's a distinction. Again, stakeholders, including local governments, have asked for something along these lines. And so that's why it's being included. And I actually think it makes sense.
Representative Espinoza.
Thank you, Madam Chair. Representative Woodrow, my follow-up question would be just the opposite of what Representative Lux is describing. As I read the bill and your amendment, the specific carve out for weapons is because law enforcement would be on premises, thus already an exception to the rule of of carrying within the polling place. And then secondarily, you would not carve them out to the subsection 3 intimidation provision because of the heightened possession of a weapon, ensuring that they could not step over the line, and any violation of subsection 3 should still be held to a standard of intimidation should they engage in that, because they've already been granted a privilege by virtue of your amendment. Am I reading that wrong, or is that how you read it?
No, you're reading
Representative Woodrow.
You're reading it correctly, Representative Espinoza.
Okay, is there any further questions or discussion? Seeing none, is there objection to adopting the amendment? Okay, seeing objection, Ms. Jackson, please poll the committee. Representatives Bottoms,
No.
Bradley.
No.
Carter,
Yes.
Espinosa,
Yes.
Foray,
Yes.
Froelich. Yes. Luck,
No.
Mabry,
Yes.
Ricks. Representative Ricks. Representative Ricks, are you with us? Excused. Clifford.
Yes.
Madam Chair. Yes. Okay, that amendment is adopted on a vote of 7-3. Vice Chair Clifford, do you want to move Amendment 2?
Madam Chair, I move L002 to House Bill 1225.
Is there a second? All right, that was seconded by Representative Foray. Who would like to tell us about Amendment 2? Representative Woodrow.
Thank you. L002 was requested by the Secretary of State's office. It clarifies that an enforcement action taken against an election judge for violating state law or a regulation or the judge's oath is not included within the scope of this act.
All right, are there any questions or comments? All right, seeing none, any objection to adopting the amendment? Okay, seeing none, Amendment 2 is adopted. Are there any further amendments?
Nothing further from us.
Okay, with the members, any further amendments? Representative Velasco.
Thank you so much, Madam Chair and members. We had a robust conversation about this issue. I urge a yes vote, and this bill will deter threats and support victims, making our elections safer and helping to retain our public servants working in this essential field, and helping Colorado keep that gold standard for election integrity in the nation. So I ask for your yes vote. Thank you.
Thank you very much. Representative Woodrow.
Thank you to all of the witnesses. Thank you to the committee for your engagement and lively discussion. This is an opportunity for Colorado to join states like Michigan, New York, Minnesota, California, Connecticut, and Virginia with respect to protecting our election workers. Just a few points on wrap up. One, thank you to Clerk Gonzalez for clarifying that this bill definitely does not increase criminal penalties. And I want to thank you to one of the opponent witnesses, and I believe the point being made was that correlation is not the same as causation. Let me be clear. I don't think any teacher should be telling students that their grade is dependent upon their political beliefs, nor should they be intimidating their conservative students or any other students. I question whether the conservative students I've met who are principled, steadfast, and certainly full of the courage of their convictions would ever be intimidated by one of their teachers about their voting preferences. What I can say is that no teacher should intimidate students, especially while brandishing a firearm. In a 2022 poll from the Brennan Center for Justice at NYU, they found that 1 in 6 election officials say they've been threatened for their work. More than half voiced concerns about the safety of fellow election workers. And the same poll found that 30% of officials knew of 1 or more election workers who left their position in part because of fear for their safety. This bill is a great step forward with respect to ensuring the integrity of our elections, and I ask for an aye vote.
Thank you very much, members. Any wrap-up comments? Or actually, let me ask Vice Clifford or Vice Chair Clifford. Do you have a motion?
Madam Chair, I move House Bill 251225 as amended to the Committee of the Whole with a favorable recommendation.
Was there a second?
Second.
All right, seconded by Representative Frey. Any wrap-up or closing comments? Representative Bottoms.
I strongly see this bill as the actual opposite of what it accomplishes, or said to accomplish. I think it's going to be an intimidating factor. I think it's going to be something that people will be stirred up to use. It's already illegal to carry guns, so that it doesn't even make sense. If it was really what it says, I know.
All right, I'm not seeing any other closing comments. Ms. Jackson, please poll the committee.
Representatives Bottoms,
No.
Bradley,
No.
Carter,
Yes.
Espinosa,
Yes.
Foray,
Yes.
Froelich,
Yes.
Luck,
No.
Mabry,
Yes.
Ricks,
Yes.
Clifford.
Respectfully, yes for today.
Madam Chair.
Yes, that passes on a vote of 8-3. All right, since it is Woodrow Day in the State Affairs Committee, we will now hear Senate Bill 59 with Representative Woodrow. He hasn't been formally approved yet, so I'm sorry. You and your fabulous outfit are on your own.
Robert is very, very conscious of that.
I know I'm being a real stickler this year.
A little different than the lawlessness when you sat in this seat. Is that what you're saying? Just do whatever you need.
Thank you for taking.
All right, Representative Woodrow.
Good afternoon, committee members. So nice to see you again. I'm proud to be presenting Senate Bill 25059, support for our state response to mass shootings. I consider, and many consider, gun violence to be a public health crisis, and mass shootings are a uniquely American phenomenon, and they are all too common in Colorado. Shootings can be classified differently within different jurisdictions, and therefore we are limited in the resources that we have when trying to extrapolate data and analyze the problem. For example, the Gun Violence Archive reports that in 2023, there were 656 mass shootings, whereas the FBI reported 41 similar incidents. There's a large difference in the numbers being reported, and victims are still impacted regardless of the classification. There are costs. The costs for responding to mass shootings is very high for the state when they do occur, and so we do need help from the federal government whenever there are grants or other resources available. This bill does two things. It defines a mass shooting as 4 or more people who are injured or killed by an individual with a firearm, not including the shooter. And the second part of the bill will require the Division of Criminal Justice within the Department of Public Safety to apply for and accept federal funding and other grants for the state's response to mass shootings. This funding can then be used towards victim support services. I urge a yes vote, and thank you for your time.
Members, any questions for Representative Woodrow on this bill? Representative Frey. Do you want to turn on your microphone?
Thank you. We are sharing a mic for some reason. Representative Woodrow, my question is, why was it specifically called out that we don't include the shooter as part of the people that are considered in the four?
Representative Woodrow.
Yeah, I think we're going to have a handful of witnesses who can testify to that. I believe that this is the most commonly accepted definition, and we are trying to be as consistent as possible throughout jurisdictions so that ours matches up as best as possible. I struggle with that myself as to whether or not the shooter should be included. But where we've landed at this point is that it is not.
Representative Espinosa.
Thank you, Madam Chair. Representative Woodrow, can you describe for us why there's a variance between the FBI statistics and ours, and whether this definition brings us in line with the FBI, or there will still be a distinction between our definition and the FBI's definition?
Yeah, so an excellent question. I believe that I'll have an expert answer it directly. My sense is that this gets us closer, and that the definitions, it's still unclear whether that is the case. It brings us in line and consistent jurisdictions. I'm not sure that the FBI definition is directly on point. For example, I know that in certain instances they count 3 or more. They'd have a definition for active shooter situation, which anticipates or envisions an ongoing shooter situation without regard to any number. So I think this gets us as close as we could be.
Follow-up,
Representative Espinosa.
Thank you, Madam Chair. I guess the reason I ask that is if the bill's intent is to align us with the opportunity to apply for federal funds, how does our definition put us in line for those federal funds?
Representative Woodrow.
Well, the definition itself, I believe by making things more consistent could assist in that effort, but separate and apart from that, the separate section of the bill on page 2 of the bill, lines 15 through 18, it requires the division to actually try to apply. It directs them to apply for those funds. So by giving them an order or a mandate essentially that they have to apply for those funds, that puts us in the best position to seek them, separate and apart from the definition. Definitionally, I think that this clears up a lot of confusion. So internally within the state, when we're talking about it, we know what we're saying. And when we're communicating with our locals, they know what we're saying. And when we report to the feds, they will know what we're saying. And I do believe that most jurisdictions have adopted the same definition.
Representative Carter.
Thank you, Madam Chair. And my question is the same line as Representative Espinosa, related to if we can align the definitions, then we will have more access to those federal funds and those federal grants. Is that correct?
Representative Woodrow.
Yes, but again, Representative Carter, the most direct sort of thing in the bill that speaks to that is the second section, which requires that we actually apply for those grants to improve our response to mass shootings. So yes, definitionally, it should help with communication, but with respect to getting those federal resources, we need to make sure that our departments and divisions are applying for them, irrespective of which party or which regime happens to be in control at the state or federal level.
No follow-up? Okay. All right, I'm not seeing any further questions. We're going to move into witness testimony. Do you have a preference in terms of who we hear from first?
How many
Supporter,
total
opposed?
witnesses do we have?
Let me look. I think we've got roughly 9.
9?
Yeah.
Is it pretty even split?
You've got 2 in support and 7 against.
Okay, let's do the opponents this time first.
Okay, great. We will run with that. Okay, we have first up Mr. Robert Valentis, Keith Emerson, Dr. Alan Fisher, Gregory Collins. Actually, it looks like most of these folks are remote, so we'll just call them all up at once. Mr. Brian Cordell, Catching Valentis, and Miss Alicia Garcia. And then Mr. Lanier, I don't know if you signed up for this one or not. Did you want to provide testimony? Oh, okay. All right. I'll call you up in the next panel then. Okay. All right. Mr. Valentis, you can begin, okay?
Thank you, Madam Chair. My name is Catching Valiant Mountain Gun Owners. Please don't pinch me. I left my green back at my seat. This bill is innocently written. No one wants mass murders happening in Colorado. No one whatsoever. What the trend has been is that the mass murders in Colorado have taken place in gun-free spaces. And a great deal of mass shootings have been exclusively gang-related, not related to many of the programs which are federally offered. Colorado already has the funds and the ability to lower crime nearly overnight if Colorado were to embrace responsible, safe gun ownership, not by the language of gun grabbers who see responsible, safe gun ownership as someone who has filled out 3,000 forms and gone through 10 different mental checks and done 5,000 hours of training. I know that I'm going a little bit further there, but particularly, I'm not interested in Colorado taking part in the Burn State Crisis Intervention Program, which will be funding Red Flag even further. It's a poor program for the state, and it should not be reinforced. The NICS Record Improvement Program just seeks to weaponize healthcare against individuals in this state. And it's clear that the sponsor of this bill and the supporters of this bill are looking for these funds to further use federal funds to cram gun control down the throats of Coloradans. That is unfit. Spend your money on stopping crime, and you'll find that there are far less mass shootings. Thank you.
Thank you very much. Let's go online to Miss Garcia. You can come off mute and the floor is yours for 2 minutes.
So I'm very much opposed to this bill, but the big deal here that we're talking about is the government saying, hey, you know what? Never let a tragedy go unpillaged and raped until we get every dime and every cent to use towards hiring more bureaucrats, to keeping their policies in place, to keeping the Democratic Party having an abundance in the House and Senate like you have now. You know, you're talking about mass shootings, but you always want to bring up the shootings that are happening, of course, as Catching says, 90% of those, 98% actually happen in gun-free zones. When you're talking about mass shootings, 48,000 people die a year, according to quote mass shootings or gun deaths. That includes suicide. But the CDC says 300,000, or excuse me, 500,000 to 3 million are actually prevented because people are armed. Now, this is a way of using rhetoric and propaganda to groom not only this generation, but the generation that we are raising into being fearful, to having terms like gun violence and mass shootings in their mind. So you're essentially making them hypersensitive. You're grooming them with trauma. And we're not really talking about the mass shootings that happen in the hood. We're not talking about the mass shootings that are committed upon the people by law enforcement. If nobody remembers July 17th, 2022, when the Denver police opened fire on a whole bunch of civilians, shooting 6 people because somebody had a gun. And the last time I checked, owning and having a gun is not a crime. But we're going to exploit the news of the children that are being sacrificed because they're left as soft targets, rather than focusing on enforcing harsher penalties to criminals and making it more difficult for people to exercise their civil rights. This is a travesty. I already know how you're going to vote.
Thank you
You
very
guys
much for your
disgust
testimony
me.
today. All right. Are there any questions for this panel? Okay, thank you all so much for your testimony today. We're going to call up Tom Mauser, Christine Burton, and Mr. Lanier. And if there's anybody else that is with us today that wishes to provide testimony on this bill, please come forward at this time. Welcome, sir. Please introduce yourself and the floor is yours for 2 minutes. Sir, we're in the red shirt. We'll have you start. Mr. Mauser.
Thank you, Madam Chair, members of the committee. My name is Tom Mauser, and I'm representing Colorado Ceasefire here today in support of Bill 59. I'm the father of Daniel Mauser, who was killed at Columbine. So I've seen firsthand the traumatic effects of mass shootings. Obviously, I've seen the trauma among parents and family members of victims. My wife and I received grievance counseling after Columbine from victims' funds, though at one point those funds ran out, so we had to use our own money. But I've also seen trauma among many others. Students who, for example, were in the library. I've known of students whose lives did not take a good turn. Alcohol, drugs, suicide, not living up to their potential, depression. And yet, following many mass shootings, we hear the slogan using the word strong a lot. We're Boulder strong, Aurora strong. And sure, it's important for communities to heal and unite. But I can't help but think that there's also an underlying denial behind that slogan, one that says, let's move on, let's move along. Hey, just get over it. This hurts our image. Well, we need more than denial. We need to provide assistance to traumatized people so that they can better return to their lives and not to somehow feel guilty about their trauma. We need to provide the authority to a state agency to seek and administer any public or private grants that may become available to respond to the needs of victims. If, and sadly when, we are struck by another mass shooting, if anyone asks how they can help, we should be prepared in advance to seek and accept help for victims. And finally, I think it's good that this bill adopts the most commonly used definition of mass shooting: 4 or more people shot, killed, or injured. And also good that we are naming a specific agency to go after the funds. I urge you to support Senate Bill 59.
Thank you very much, sir.
Thank you.
Mr. Lanier.
All right. My name's Kellen Lanier again. So I'm more of an amend position here. Just hearing some of the introduction here, I have some questions about it. Is this bill wise at the moment, given that it's seeking federal funds? Also, if we don't really know the mechanisms of the bill, should we be pushing it at this moment? Should we take some more time to think through it instead of saying, I don't know? And then why not use Prop KK funds to fund it instead of federal funds? But what's more, can this bill be amended to address some of the issues that influence violence instead of being reactive? Is there space to create funding to be proactive, creating community programs that have been proven by the same data I think that some of you espouse? It's more effective in curtailing violence. So I'm wondering if there could be amendments to shift funds, to precursors versus, oh, something happened, let's support, and use Prop KK funds for support and use bigger funds to prevent it. So it just doesn't happen in the first place. So we don't have to come here and get screamed at constantly and demeaned. I think what we see here is a product of a lot of what you would call manufactured reality. And I want to make sure that our lawmakers are not falling, victim to that and creating policy that does not actually help the way that they are saying and thinking, and aligning that thinking with action.
Perfect timing. Thank you very much. Let's go online to Christine Burton. Please come off mute and the floor is yours for 2 minutes.
Thank you, members of the Veterans and Military Affairs Committee. I'm here to speak for the Colorado Faith Community United to End Gun Violence. I'm here in favor of Senate Bill 25059. I'm speaking on behalf of the benefits that the state will receive when writing grants for additional funding to research and to help victims of mass shootings. I also want to say we are not choosing between protecting our Second Amendment rights and protecting the victims of mass shootings. We can do both things at the same time. That's the magic of being a human being. We know already that the mass shootings and the fear surrounding them are permeating human life, our communities. We want to create more safety for our children, and one way to do that is to provide some research for that and also provide resources to victims of crime, of mass shootings. This bill will do that. We can afford and should be able to afford putting money towards helping people that are victims of mass shootings. I encourage you to vote yes and give us the opportunity to bring money into the state that will help the victims and will also give us more solutions to prevent the epidemic of mass shootings. Thank you for your time.
Thank you very much. Members, do you have any questions for this panel? Okay, seeing none, thank you all so much for your testimony today. Is there anybody else here that wishes to provide testimony? All right, seeing none, the testimony phase is now, oh, I just saw a hand come on down. Welcome, please introduce yourself and the floor is yours for 2 minutes.
Thank you. My name is Nicole Green. I'm a resident of downtown Denver, an OIF veteran, and I support this bill. We really have to find a balance, and thank you all for your time today.
Thank you very much. Members, any questions? Okay, thank you very much. All right, the witness testimony phase is now closed. Representative Woodrow, any amendments? All right, committee, any amendments? Seeing none, the amendment phase is now closed. All right, bill wrap up. Representative Woodrow.
Thank you, committee members. And just to go back to some of the questions that were asked during my opening, the federal government has no official definition. In 2012, Congress defined mass killings in a limited context to be 3 or more. The next year, the Congressional Research Office, over 40 pages, adopted a different definition for public mass shooting, and the FBI does not define mass shooting. It has defined mass murder and active shooter in very different concepts from what we're talking about here. This will require us to apply for federal funds. It doesn't pay for anything with federal funds, just to be clear about that. What it says is that if there are grants, federal grant monies available, that we should be applying for them so that, heaven forbid, we do have another one of these incidents, we have the support necessary for the victims. No one wants these incidents to happen. They are an unfortunate current reality, and this is a step to making sure that we can have the right data. So I ask for an aye vote.
Thank you very much, Representative Woodrow. Vice Chair Clifford.
Madam Chair, I move Senate Bill 25059 to the Committee of the Whole with a favorable recommendation.
Second.
All right, seconded by Representative Foray. Closing comments. Okay, seeing none, Ms. Jackson, please poll the committee.
Representatives Bottoms,
No.
Bradley.
No.
Carter,
Yes.
Espinosa,
Yes.
Foray,
Yes.
Froelich,
Yes.
Luck,
No.
Mabry,
Yes.
Ricks,
Yes.
Clifford,
Yes.
Madam Chair.
Yes, that bill passes on a vote of 8-3.
Thank you, committee.
That concludes Woodrow Day in the State Civic, Military, and Veterans Affairs Committee, and our meeting is now adjourned.